Any mention? Please, Lordships. Lordship, I beg to mention item 8 and 9. It's a connected matter, Your Lordship. Lordship, I pray for 2 weeks' time, Your Lordship. The conducting counsel has some personal difficulty, Your Lordship.
Your appeal should not be delayed. It is said that, you see, if we are not saying that it's a hard and fast rule, but perchance the person is innocent, even 1 day of prolonged custody would affect them. So it's incumbent upon the parties to
just reduce the same maybe next time.
Your Lordship, positively by after 2 weeks.
on premium by the direct counsel for the appellant seeking accommodation on grounds of personal difficulty. The same not be objected to by the state respondent. Matter is adjourned. This is after 2 weeks. 8, 9.
Oblige.
My please, Your Lordship. Lordship, I beg to mention item number 10. Lordship, I pray for 3 weeks' time, Your Lordship.
Why 2?
Conducting counsel is having some personal difficulties, Your Lordship.
Personal difficulty, but it should not stretch till 2, 3 weeks. We'll give you 2 weeks.
Lordship,
Premium by the appellant. This is matter after 2 weeks.
highly obliged.
May I please, Your Lordship, I beg to mention item number 6. Item number 6. I'm praying for 2 weeks' time. The senior counsel is in bereavement.
Oh, bereavement. Mention is made on behalf of the learned senior counsel who is conducting this matter, seeking accommodation on ground of bereavement of such senior counsel. On the same not be objected to by respondent, matters adjourned. This is after
2 weeks, Your Lordship. Item number 1.
As per record, it says on 21st the record has received from the law.
Now, have you prepared a paper book?
We'll prepare a paper.
Mr. SP Manta, learned senior counsel, appearing for the appellant, has sought for some more time to prepare the paper book. Pray aloud. This is matter of the
Within 2 weeks' time, we'll prepare.
2 weeks.
Because there is urgency for the bail also. I have to much obliged.
5.
May it please your lordship. 5 is linked with item 4, your lordship. Same order will follow.
Same order?
Lordship.
Same order. Okay.
Offline.
Item number 7.
Please, your lordship. This matter is for final hearing now. No?
Huh?
This is for final hearing. The accused persons were, the petitioners here as accused persons, they were convicted in the year 2023, and thereafter they have come on appeal before your lordship. The conviction is under 302 and sentenced to life imprisonment.
Okay.
Now the paper book is available.
Yes.
My lord. My lord, if your lordship comes to page number 5 of the paper book, is the Ejahar in Khasi, and the translated copy is at page 6.
Yes.
Your lordship will come to page 6, my lord.
Yes.
My lord. To the officer in charge, Umulong Police Beat House, Umulong. I beg to inform you that on 16/11/1991, so it's an old case, my lord, of 1991, at around 4 p.m. at Lumkudung village, Sri Sada Muro, son of U Nihan Suting, Lumkudung, has been murdered by 5 persons from Lumkudung village by the name Sri Tingen Muru, son of U Kyang Suting, he is one of the petitioners, Sri Loit Muru, son of Kyang Suting, Sri She Muru, son of Kyang Suting, this is another petitioner, 4 Sri Tne Muru, son of U Kyang Suting, and Sri Kamai Muru, son of U Pil Ludin. The murderers were all from Lumkudung. Now, out of this, my lord, only 3 of them survive, and the 3 of them have been convicted.
Who is deceased?
This is the Sadamuru, and this is accused, my lord. My lord. So, the surviving accused are Tingen Muru, number 1, and number 3 and number 4. 1, 3 and 4 surviving, my lord, and they have been convicted.
So these 2 others were deceased in course of
In the course of the trial. In the course of the trial. So therefore, I request you to kindly look and investigate into the matter and to arrest the 5 persons named above. The witness who witnessed at the time of assault and murder of Sadamuru, Sri Dal Rinklem, and the father of Sadamuru have also been assaulted by these persons. So this is the Ejahar which has been filed, my lord. My lord, the next page, section 7, is the charge sheet. The prosecution story of the case in brief is that on 16/11/1991 at 4 p.m., deceased Sri Sada Muru, son of Nihon Suting of Lumkudung village, was killed by accused. All those 5 persons are named below. All of Lumkudung village. Hence, this case was registered and investigated into. During the investigation of the case, prima facie case under section 30234 IPC was found well established against the arrested accused, Sri Tengen Muru, Sri Lu, all those 5 persons will have been mentioned here. I therefore send them up to face trial in the court of law under the aforesaid section of law. The witnesses noted in column number 14 will prove the case, which may kindly be summoned by fixing date. Enclosed herewith one original post-mortem report of the deceased Sri Sada Muru of Lumkudung, inquest report and dead body challan. So the charge sheet is dated 14/5/1994. So 91 is the incident and 94 the case was charge sheeted. Below, the list of witnesses is at page 7, but
Page 7.
sorry, page 15, serial page 15. 7 is the internal page. Well, the typed copy is at page 23 of the list of witnesses.
Yes.
Now, out of these, Milord, only 3, including the doctor, Milord, 3 witnesses only were examined. Others were not available or not produced for examination.
Who are those?
The witnesses who were produced, Milord.
Serial number?
My lord, the one who filed the complaint, Milord, Kayamuru,
Yes.
and Mandamuru, number 1 and 2, Milord. These have been examined, and Dr. P. Thubru, the one who conducted the postmortem. These are the ones which are available in the record, Milord.
The IO was not examined.
I was also not.
He died, expired.
In fact, the IO who conducted the investigation, the charge sheet was filed by some other IO, Milord. But anyway, Milord, they were not, none of them were. Nobody was examined. Nobody was from the police department at all was examined.
Yes.
Now, Milord, the deposition of the witnesses start from page 27, Milord. And the typed copy is at page 33. Similar, the name of the witness is Srimati Manda Muru, the one who is at serial number 2 in the list of witnesses. Your Lordship, page 33, minute. Malad. I know all the accused persons who are present in court today. One Sada Muru, who is now dead, was my younger brother who died on 16/11/1991. He was murdered by all the above accused persons. I saw the occurrence myself. The occurrence took place around 6:30 p.m. to 7 p.m. on the said date at the paddy field belonging to my mother, Ka Kwen Muru, at Lum Kudung. Immediately after the incident, I asked them as to why they killed my younger brother, who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which in fact was not true. I do not know the reason why they killed my younger brother. Now, cross-examination, Milan. I was at my place of work from 13/11/91 to 16/11/91 at Sung Valley, where I make harvest of my paddy. I reached home on 16/11/91 at about 6 p.m. The paddy of my mother is at Lumkudung village and met at mine, it should be, I think, at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal and got ready for bed. Then at that point of time, the accused came and dragged my younger brother to the paddy field of my mother. At that time, my brother Usada Muru, Ukala Muru, Kakwen Muru, mother, Nihon Suting, father, were also present at home. Then we did nothing to follow the accused along with our brother Usada Muru and asked them not to beat him. The distance of the paddy field from our home was about 100 meters. The time when they dragged him from our house is just before 7 p.m. During the dragging process, the accused person also manhandled my brother Upaya Muru. My father also, Nihan Suting, was assaulted by the accused. We did not inform the headman about the incident on the said date and time, but have, however, made hue and cry, to which none of them came to rescue. It is a fact that my brother Usada Muru was left in the paddy field on 16/11/1991 till 18/11/1991. On being queried as to why she did not take her mother Usada Muru to her home immediately, she replied that her religious practice in a Niamtre is not permissible to carry home in case of a person who met with an unnatural death. It is a fact that my brother Ukaya Muru reported the matter to the headman of the Lumkudung on 18/11/1991, and thereafter a complaint was lodged with the police. I state that the FIR lodged by my brother is wrong to the extent that I am an eyewitness. I do not know who attacked first the deceased. I was at a distance of about 3 to 4 meters from the place of occurrence. During this winter season on that particular night, it was still visible to the naked eye, though the time was 6:30 to 7 p.m. at night. I was not at all examined by the police. The police examined only my mother, Ka Kmen Muru, and my sister, Ka Soli Muru, on 18/11/1991. Subsequently, I was examined by the police and I have told them that the incident took place at 4 p.m. My statement before the police about the time is uneven, and my time before the court about the timing of the occurrence is correct. It is a fact that I never stated before the police that the accused person dragged my brother Usada Muru from our residence on the alleged date of occurrence. It is a fact also that I never stated before the police that my brother Ukaya Muru and my father was assaulted and manhandled by the accused persons. It is a fact that my deceased brother was a lunatic. It is a fact that my brother is hospitalized and is in mental jail Shillong. It is a fact that my deceased brother was a criminal lunatic. It is a fact that only when he was provoked that he became violent. I do not know if my deceased brother destroyed the ripe paddy of the accused. It is not a fact that my brother was not dragged from home on this date and time of occurrence. It is not a fact that my brother and the accused were already in the paddy field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created trouble, and on time and occasion the Dorbar Shnong directed us to hand over to the police, and thereafter they sent him to mental jail Shillong. I was not present on 18/11/1991 when the police came and inquired into the death of my brother. I do not remember at what time the police arrived at the paddy field of my mother on 18/11/91. I arrived at the paddy field of my mother at about 8 p.m. on 18/11/1991. I was at home on 16/11/1991 at 6:30 p.m. I went to report the matter to the police on 17/11/1991. My brother was not taken to hospital for post-mortem. So that is the statement of the PW1. Now, below PW2, this PW2 is the one who filed the charge sheet, Millard. I received summon to appear and depose before the court today. In the year 1991, I was posted at Umulong Beat House as the in-charge. The instant case was investigated by SIQB Pala, and on his transfer, I was directed by the then SP Joai to file charge sheet in connection with this case, with a charge sheet number 37 of 94 dated 14/4/1994 under section 30234 IPC. I do not know the accused persons in this case. So he has not done anything regarding the investigation. Under instructions, he has just filed the charge sheet. Millard, next is Kaya Muru.
Yes.
Page 38, Millard.
Yes.
Millard, I received summon to appear and depose before the court today. I know the instant case as the deceased victim Sri Sada Muru was my brother. I cannot remember the date, month and year of the incident. On the day, Millard, of course, here, Millard, this witness was examined in the year 2022 only, after the separation of duty. The previous witness was examined when the judiciary was not yet separated, the first witness. This witness is examined only in 2022. So she says that she does not, I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother. At around 6 p.m., one Sri Dal Rinklem came to our house, and after some time he left our house. Thereafter, my victim brother went out of the house and I saw 5 persons chasing my brother. Witness number 1 has said pulled out of the house. This witness says chasing my brother, and caught him at the paddy field and started assaulting him. On seeing my brother being assaulted, I, along with my parents, rushed to the paddy field to stop those 5 people. The witness number 1 had said that they had done nothing. But this witness says that they have tried to interfere and stop those 5 people, but they still continuing assaulting till he died on the spot. So they were very near and close to the, allegedly or statedly, to the victim and the persons who assaulted him. I know the 5 persons who have assaulted my brother, and their names are Tingen Muru, She Muru, Thne Muru, Kamai Muru and Lomit Muru. All belong to Lumkudung village. Today only accused Shemuru, Tnemuru and Tingenmuru are present. Others had died by that time. In the court dock. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the PO. I, along with my elder sister Yongmuru, went to Umlong Beat House to report the matter to the police, and the FIR was typed by someone whose name I cannot remember now, and I have signed in the FIR. Exhibit 1 is the FIR and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some inquiry at the PO. I do not remember now if the doctor also came to the PO. Later, the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. Now, the cross-examination by the State Defence Counsel. Chakravarti, he is also Chakravarti, not me, Milord. The Chakravarti from Joy. It is a fact that I have informed the police about the incident at about 8 p.m. It is a fact that whatever I have deposed before the court today is true and correct, and the statement before the police that I was informed by somebody about the incident is not correct. It is a fact that me and my other family members just stood at the PO requesting the accused not to assault the victim, but we did not do anything as we were all scared. It is a fact that only we, the family members, witnessed the incident at the PO and none of the villagers saw it. At the PO, it was me, my father, mother, and 2 sisters, namely Yongmuru and Dinamuru. So she does not mention the PW1 were present. The dead body of the deceased victim was lying at the PO for 2 days from the date of incident. I saw that all the 5 accused persons together assaulted my victim brother. I had informed the police about the incident at Umulong Beat House. So this is number 3. And number 4 is the Dr. Millard, who had conducted the postmortem. That is at page 40, Millard. Dr. Thubru. I received summon to appear and depose before this court today via VC, as I am not in good health and is not in a position to personally appear before the court. I joined service in the year 1980 and was posted at Umulong Dispensary. In the year 1991, I was posted at Joy Civil Hospital. I received a requisition from the police to conduct the post-mortem on the dead body of Sri Sadamuru, male, aged 23 years, at the spot or place of occurrence, which is the paddy field of the deceased mother, Kwen Muru. The examination was conducted on 18/11/1991 at 2 p.m. Now, Milord, here thorax, these are in the report, Milord. Most of the, anyway, I'll take your lordship, Milord. Firstly, it is the thorax. Here, Milord, all the parts, they show to be healthy. These are not affected. Now, then, next page, Milord, page 41, muscles, bones and joints. Now, injury is nil, disease or deformity is nil, fracture is nil, dislocation is nil. So, there was no injury or dislocation or disease or deformity or fracture on the muscles and bones. Yes. External appearance, condition of the subject, normal. Wounds, position, size and character, nil. Bruises, position, size and nature, nil. Mark of ligature on neck, dissection, etc., there was nil. So there was no mark of ligature on the neck. Abdomen, Milord, walls, peritoneum, mouth, pharynx and esophagus, stomach and its contents, small intestine and its contents, large intestine and its contents, liver, spleen, kidneys, bladder, organs of generation, external and internal, all are healthy. So, Milord, this next part, external appearance, this is relevant, Milord. Scalp, skull, vertebrae. The head is broken. The only injury was on the head. The head is broken. Membraro, ruptured. It is a membrane in the skull, I think, Milord. Brain and spinal cord exutused. I think it has come out of the skull, Milord. After examination of the dead body, I found the head is broken, the membrane ruptured. Lacerated injury on the chin and the chin is broken. Lower lips disfigured. Incised wound on the left supratemporal region measuring 3 by 2 centimeters. Upper jaw and 6 teeth broken. In my opinion, the cause of death was due to hemorrhage resulting from the above injuries. I have also prepared a report after the post-mortem examination was observed. Exhibit 2 is the post-mortem examination report and Exhibit 2/1 is my signature. Very relevant, Milord, in this post-mortem report, Milord, the time of death is not mentioned. At what time the person died. Injuries are mentioned and for which hemorrhage has occurred, that is mentioned. But the time when the exact death took place, normally in a state post-mortem report, time is also mentioned. But here that is not mentioned. So cross-examination was declined. Now, Milord, after that 313 CRPC examination, those are also given. They have denied all the accused persons. They have denied. They have not said anything. Also, they have simply denied the allegations. Now, Milord, two headmen. Headman was examined not as a witness, but only because to prove the death of some persons. That is at page 58. Death of the witness. So this person is the headman of the Madur village. I received someone to appear before the court. I know the witness Srimati Yoka Muru, daughter of Srimati Kwen Muru and Sri Nihon Singh, as she was a resident of Madur village where I am the headman. I state that Yoka Muru expired on 13/6/2006 and she was cremated at Madur village on 15/6/2006. I have also issued a certificate to this effect on 19/3/2020 as the family members have not obtained her death certificate.
What is the relevance of this?
Just to prove that one of the witnesses died. Otherwise, to the actual incident or to the actual case, there is no relevance. No relevance.
And this was also not being, examined, or the position was not taken in the proper format. Yes, as much as he is not a witness.
I think this is not very relevant. Even the next one. Same, the son of this Dal Rinklem, that his father has expired. Now next also, Milord, that Nihon Singh's daughter, Milord.
That's what they have not come as PW. That is why I'm saying.
They did not come as PW.
An evidence during the course of the trial.
They were examined.
During the course of the trial.
During the course of the trial.
As PWS or what?
My lord, they were.
Witness or what? What was?
Relevance.
No. They came as what? Witness, prosecuted witness.
It's not clear, my lord.
Court witness or as a defense witness?
Nothing is clear, my lord.
Were they summoned?
Probably the.
Yes, because the prosecution desired it, or the court of its own called them.
It's not clear at all. My lord, I'll take your lordship to the judgment.
Something should be there in the record. How
it should be. It should be. Nothing is there. So why they were called, under what circumstances? My lord, from their deposition, the only thing which has been made out is that they are deposing that certain witnesses had died. Only that much. So that actually thought that there was no requirement to call them. I think, I'm not very sure why they have been called, Milad.
Yeah, I think this is just to see, perhaps summons have been issued to them.
It must be.
They have not appeared to confirm that they have, they have since deceased.
In response to those summons to those.
The headman was.
Something like that must have happened. So, Milad,
Look at the order sheet. Look it up. That's why it has to be bolded.
So, Milad, if I can take your lordship to the judgment, Milad. This is all the evidence which has was adduced, and the judgment is on the basis of this.
As per the judgment, how many prosecution witnesses were examined?
4.
4. So
They have not been taken into consideration.
That is, they have not been taken.
They have not been taken. Yeah, it's from the effective is from page 99. 98 is from 98 and 99.
This is the impugned judgment.
Impugned judgment. Judgment is dated 4/8/2023. Sentence is subsequent to that. Probably sentence was 7. Anyway, I'll take your lordship to the judgment minute. But at page 99. The criminal proceeding in the instant case was set in motion 3 decades ago by Sri Kaya Muru, brother of the deceased Sada Muru, by filing an FIR dated 16/11/1991, alleging that 5 persons, namely Tingen Muru, son of Wu Kiang Suting, Sri Loit Muru, son of Kiang Suting, Sri She Muru, son of Kiang Suting, Sri Tne Muru, son of U Kiang Suting, and Sri Kamai Muru, son of U Pil Luden, from Lumkudung village, murdered Sri Sada Muru, son of U Nihan Singh Suting of Lumkudung village on 16/11/1991 at around 4 p.m. at Lumkudung village. FIR mentions 4 p.m. It was further alleged that all the murderers were from Lumkudung village, and Sri Dal Ringklim and father of Sadamuru were the witnesses to the assault by the accused persons. So in the FIR, it is not stated that anybody else was a witness. Only 2 persons, this Dal Ringklim and the father Nihon Suting, I think. These 2 were only supposed to be the witnesses who saw, as per the FIR. The FIR was lodged before the officer in charge Umulong Beat House, Joai, which was forwarded to Joai Police Station on 18/11/1991 and registered as Joai PS case number so-and-so under 302 and 34 IPC. Case was taken up for investigation by in charge Umulong Beat House, SI QE Pala. The order sheet reveals that the 5 named accused persons in the FIR were arrested on 19/11/1991 and released on bail by order dated 3/12/1991. The IO found the dead body of Sada Muru on 18/11/1991 in a decomposed state. Postmortem was conducted at the PO. The investigation culminated into a charge sheet, being charge sheet number 37 of 1994, dated 14/5/1994 under section 302-34 IPC against all the 5 named accused persons. The IO, relying on the statement of the 10 witnesses, filed the charge sheet. It is pertinent to mention that the charge sheet was filed before the Additional Deputy Commissioner Joai. After filing charge sheet on 1/3/1995, copies were served to the accused persons in compliance with section 207 CRPC. Charge was framed against all the 5 accused persons on 22/5/1995. The 5 accused persons pleaded not guilty and demanded for a trial. The accused Kamai Muru died during the course of trial on 18/8/2018 and he was declared dead with a order dated 14/2/2020. The accused Luit Muru reportedly died during the course of the trial. However, there is nothing on record showing that Luit Muru has been declared dead. The trial proceeded against the accused Tingen Muru, She Muru and Tne Muru. From the record, it emerges that after framing of charges on 22/5/1995, the matter was posted for evidence till 31/5/2005. For 10 years, no witnesses were examined. Thereafter, on 11/7/2005, the case was transferred to Fast Track Court, Joy, for disposal and the matter was posted for evidence before the Fast Track Court. The learned Fast Track Court, with a order dated 17/3/2010, has observed that the matter was posted for evidence for 10 years. No witness has been examined due to the non-appearance of the accused. The matter was again posted for evidence. No witness was examined. After the separation of judiciary from executive in the district of West Jaintia Hills District, Joy, the case was transferred to this court on 17/9/2015. This court, with a order dated 29/10/2015, posted the matter for evidence and appearance of the accused. Learned Counsel Sri S. Chakraborty was appointed as State Defence Counsel with a order dated 12/1/2016 to represent the 4 accused persons. The order dated 14/2/2022 reveals that the accused Kamai Muru expired on 11/8/2018. PW1 was examined on 6/8/2021. PW2 was examined on 3/2/2022. PW3 was examined on 8/3/2022. PW4 was examined on 21/3/22. The remaining witnesses expired and could not be examined during the course of trial. The witness Yuki Muru died on 13/6/2006. Dal Rinklem died on 7/5/2006. Witness Nihon Suting died in the year 2018. Witness Kumar Kongwir died on 19/11/2010. The Ayo Kiwi Pala died on 6/11/2022. The prosecution during the course of trial examined only 4 witnesses. Thereafter, the 3 accused persons were examined under Section 339 CRPC on 22/6/2023. The accused persons were given an opportunity to bring defense witnesses. They declined to bring defense witnesses. As such, the matter proceeded for final hearing. Heard Learned Additional PP Sri S. Changsan. Heard Learned Counsel Sri S. Chakraborty representing the 3 accused persons, Tingen Muru, She Muru and Ne Muru. Prosecution argument.
So means there is nothing in the judgment how those evidence came into record.
Nothing. Nothing. No mention at all. Those.
Don't you find it a bit mysterious?
Well,
It may not have any relevance, but
But
then
should have been
how
mentioned.
could that remain a part of record in a criminal proceeding?
Right. Unless and until it has been referred to in the judgment or anywhere, any other relevant portion.
That is what for you to say. We do not know what is there in the order sheet of the trial court. Basically, that is for you to clarify, throw light on those. Should not be something that a mystery remains in the file. If a criminal court passes a judgment, it has to be in detail and it has to deal with all the evidences on record, whether relevant or irrelevant. If they find something is irrelevant, then it should be pointed out written here, this is not relevant. But then there must be something in the judgment.
More than what is available here, beloved, we do not find anything else. Because
can we ignore that thing, though it is
probably,
irrelevant,
I think it should be ignored only. Although it is there in the
without taking notice of the thing, that it was recorded and it was...
Because the judgment does not refer to it at all. Judgment
That is very surprising.
The judgment records the death of the witnesses, but on what basis the death of these witnesses has been learnt of, that is not mentioned. Whether these statements are the ones from which the court, honorable court, came to know about the death of witness, that is not mentioned here. So no reference at all.
That remains, of course, those persons have not come before the court to be examined as witness.
Right, right.
So we may not go into that aspect.
Right, right.
Okay. But then at least when there appears some evidence, there are some evidence on record, the judgment should deal with it.
It should have at least mentioned that these are there and whether these are relevant or not relevant. What is the purpose? I think, Milord, of course, this is not a very relevant submission, but what appears to me, Milord, is maybe because of the change of the presiding officers. Maybe when those witnesses were recorded, the presiding officer was the previous presiding officer. Subsequently, when the judgment was written by the concerned presiding officer, probably he did not find that. Anyway, Milord, it should have been mentioned, at least, that these are on record. In the paper book, it is.
Some of them are eyewitnesses.
No, these witnesses, or those who died, stated to be. Oh, right.
Now what happens if you have to make some observation regarding non-examination of other eyewitnesses? Then what happens? Whether those evidence become relevant or not? If you have to find out some deficiency with the prosecution, the conduct of prosecution of the case, and if you have to hold that yes, that without sufficient ground, the prosecution has refused to examine eyewitnesses, then whether those evidence would become relevant.
Because these evidences, at least for two of the witnesses, Milord, these evidences show that they are no longer available.
That's all right, but then there is nothing, no mention about these things. Then if we ask a question, then what is the reason of non-examination of those eyewitnesses? Then what would be the answer? If those evidences
Have not been referred to.
find place in the judgment, then can you give an answer basing on those evidences?
Yes, and what about the statement of those deceased witnesses? Statement under 161, 164?
My lord, under 164, I think some 164 statements are there. I will just take your lordship. My lord, these 164 statements.
You see, when a witness has been examined under 161, you see, the principle is that evidence is usually not taken into account except for corroboration or contradiction. 161, 164. Except for contradiction. But in case, you see, now this person who has made such statement before the police initially, course of trial expired before giving his evidence. What is this? What would be the value of his
161.
161 or 164? Would it stand in law or it has to be discarded altogether?
You know, 161 statement, unless it is established during the course of trial, I think it cannot be taken into. Miller, 164 statement, here the only 164 statements which have been mentioned are these three. These which your lordships have noticed, Miller, that these persons who came to state that the witnesses have died, these statements are stated to be under 164. These are not, that means these witnesses were not called, as your lordships has observed already, that these were not under
Please,
oath.
Sorry, you want to say like those witnesses who have been examined as prosecution witness, they gave a statement under 164 also.
No.
Then who gave statement under 164?
These three witnesses who came to say that the actual witnesses have died.
No, but then these are statement under 164.
That is what, Milord. It appears that is why there was no oath administered. As your lordship has.
So you are going the assumption there.
No, Milord. It is stated, Milord. If I can take your lordship back, Milord, to that.
Now, what is the date of recording of the statement? We can find it out from there.
Yes, yes. Yes, it can be understood from there.
There cannot be 164 statement in the middle of the trial of the case, isn't it?
My lord.
It has to be at the stage of investigation.
My lord.
Yes. So let us see what is the date of that close. And when this matter start.
Page number 58 million. 30th of June 2022. Much after the.
At the stage of, after the trial begins.
My lord.
Then
My lord.
definitely 164 has to be at the stage of investigation.
My
isn't
lord.
it?
My lord. Here, my lord, from the deposition, from our recording of deposition, it does not disclose also that it is a statement under 164. But I don't know, in the
What is the order sheet of those days? What does it? What do these order sheets say? Order sheets of the court.
my lord, we'll have to check that. As far as these witnesses, as far as the final judgment is concerned, they have not taken this into consideration.
If you find it necessary, then no, if it is necessary to go into that. Yes, as my brother said, I think we have to clarify this point first.
Madam.
If that has to come, by way of an observation.
We'll check the order sheet.
See, provisions here. Probably 386 cast it out on the appellate court to deal with all the evidences. So whether it is relevant or irrelevant, whether you make an argument on those or not, at least you have to take notice of that. And for doing that, you have to say that such and such statement was recorded at what stage, whether under 164 or in the course of the trial and all. So that things.
I will try. I'll go through the order sheet.
Yes, you have to go through the trial court record.
Order sheet. We'll do that.
You have any idea, Mr. Guru, about those things? At what stage? Those?
7 except the paper book. I have not checked.
You have to also check also. You have the equal responsibility of clarifying things.
We'll do it, man. Both of us will do it.
No mystery should remain.
Right. So sometime maybe.
When?
Miller was also quickly to check the.
This is what my lord was saying. Once we start something daring, we should.
Well, a little, maybe a couple of days.
A bench sits once a week, if I'm not mistaken.
Oh. It may come up next week, or what?
It's up to you. Whatever is convenient to you, just.
It may come up next week. In the meantime, we'll check.
Heard Mr. S. Chakravarti, learned senior counsel, appearing for the appellant. Matter is partly heard. On the matters partly heard. No? Mr. S. Chakravarti, senior counsel, appearing for the appellant, has prayed that this matter may be taken up on the next day. May be continued, that the hearing may be continued on the next day. We will not observe that you have to go through all those things.
Matter.
As prayed for.
We'll do them.
This matter for further hearing on. Next.
Next week we'll do.
So next week will be 12th then. If we have to sit on 12th. This is matter of the whole week.
Deeply applies.
There was no murder weapon, no weapon of murder.
That's what, Milord. That I'll be harping strongly on that, Milord. Skull has been broken. No instrument has been mentioned. Obligation. Obligation.
Item number 1.
Please, Lordship. I'm entering appearance, Lordship, for respondent number 1 today.
Number 2.
We have some time, Lordship, to allow us to file any objection.
My lord, number 2 is the collector, my lord. We have taken steps and we filed an affidavit to that one. The service is complete for collector also.
Notice has been effected.
My lord, we filed affidavit, my lord. We filed affidavit on 9th of December, my
But
lord.
I thought about it. I don't think I'll be able to take up this matter. The fact being, you are aware, in another matter involving the same person, I have recused on personal ground. So if I take up this one, then person will.
With this, Justice thank you is also recused, my lord. And Justice Bhattacharya will not be because he was there for the trial court, my lord.
I've thought of that. What can we do?
My lord, we have no objection, my lord. Otherwise, I don't think they'll have objection also. Lordship may kindly consider next date, my lord. Let them file a so-cause by at least.
Well, you see, we're not talking about the contents of the
My lord,
or
my
merits
lord, I
of the
understand.
case as such.
My lord.
I don't think I'll be able to take up this one. Anyway, since you said that, we'll see on the next date.
Next date, my lord.
Dr. Musika, the SGI has submitted that the notice issued upon respondent number 2 has since been effective, and an affidavit of service has been filed in this regard. So, as far as respondent number 1 is concerned, the counsel has entered appearance on behalf of such respondent and has submitted that he may be allowed.
Lordship, we've just been appointed. Can you allow us to take instructions first, Lordship? Because there is a miscase pending, Lordship, the condonation application.
Condemnation of delay also.
Competition. And has prayed that he may be allowed some time to seek instructions as far as the application. Under Section 5 of the Limitation Act is concerned. Accordingly, on premier, this is matter of 2 weeks.
Item number 2.
Yes.
Lordship, the respondent number 2 is supposed to reply on the report, Lordship, as per the order.
Who's the respondent number 2?
I'm the respondent number 2, my lord.
No, who are you?
I'm the accused,
You're the accused.
Your Lordship, and the bail was granted.
In your favor.
Yes, Your Lordship.
Before my time starts, my lord, Madam NG Sheila is in this case, my lord, but today, due to some reason, my lord, she is not available. So I pray if the matter can come up, because without her instruction, my lord, it will be difficult for me to make any submission out here. On the last occasion, she has produced the status report. So if at the later stage of the hearing, I am unable to reply satisfactorily, my lord, it is for cancellation of bail, and my lord was pleased to find a query on whether the locus standi is maintainable or not, because it's not on the report of the IO, or the IO has not come forward for cancellation of bail, but certain thing was reflected in the status report, my lord, which says that he was not cooperating, my lord. That is there, but it was not our application for cancellation of the bail.
Oh,
But the IO has prayed in his report, Lordship, that bail may be cancelled. The report might be in the record also, Lordship. The IO has, as per the status report of the IO has prayed to cancel the bail because he is not cooperating with the investigating agency. Even Lordship, today is for many dates are given to get his signatures, Lordship. But till today,
whose signature?
the accused person's specimens, handwriting and the signatures for the verification of the documents.
That is why you see it is for the IO to.
Yes, Lordship. The IO has already given in his status report, Lordship. The IO has already in his status report has prayed.
What is the latest status? When was this last status report of file?
I think
I think that would have been before vacation.
16 December.
before vacation.
As of now, what is the stage? What is the status?
It has not, the first status report has.
Not aware.
Because we don't know between that time and this time
Lordship.
whether the accused had
My lord, we
appeared
have
before the IO, whether what is
my
it?
lord, we have communicated to the IO because the this accused is sick. He is aged person. He is sick. We have intimated to the IO, and we have appeared also. My statement has already been recorded under section 161 CRPC. All the formalities has been done, but at the instance of this petitioner, your lordship, again this has been reopened, and then now the IO is also taking interest, so much interest, my lord, and the petitioner is also aware that what is going on. It has to be within. It has to be between IO and the accused. But now the petitioner is know everything, your lordship, that he is not appearing, he is doing. So it appears that your honor, he has no locals, but still, I don't know.
See, that aspect of the matter will be
Yes.
looked into. When it comes to an application for cancellation of bail,
Yes, your lordship.
see, there are very
Cogent.
limited grounds.
Yes,
Limited ground.
limited ground, cogent and overwhelming circumstances are required, your lordship. So
Lordship.
But I think it will be better if we get the latest.
Lordship, on as per the Lordship's order on last date, they are also the respondent number 2 also are supposed to file reply on the status report. The copy of the status report was not to me, Lordship. I have not received what Madam NG Sheila she read out before the court. From that only I drawn the inference. So the copy of the status report was with the accused person, Lordship. On base of the status report, the accused persons are supposed to file a reply on the base of the for their they are supposed to file reply on the based on the status report as per Lordship's order, which is not even complied, Lordship, today also. They have not come up with that reply.
Why you have not done so?
Because now fresh status report has been called for. As Lordship, today, Lordship is pleased to call for fresh status report. But based on the previous status report, they are supposed to reply.
we will reply. At the time of hearing, we will reply. It is not that mandatory that we have to file in writing only.
It's not. Yeah, it is not said that he has to reply in
Yes.
writing.
Yes.
He has to respond.
Yes, your lordship.
Lordship.
See, there are two issues to be decided here. Firstly is the locus of the petitioner.
Yes.
If that is decided, then we will look into another factor, another aspect of the matter, that is whether
Ground for cancellation.
there are grounds for cancellation.
Yes, Your Lordship. That's
So, and for that, it would be incumbent upon the prosecution too
yes, Your Lord.
to substantiate
Yes, yes,
whether those grounds are, are present or not.
yes.
Lordship.
As far as you're concerned, you see, for all intent and purposes, you may have an interest in the matter, but that is not a record. Number one. Number two is you may be, we can just assume that you are an interested person who is interested in the outcome of the matter.
Lordship.
So that also.
Lordship,
you-
now the
so
prayer
what-
from the IO has also come up, Lordship. It's not only my prayer. The IO has also
If-
prayed.
If that is the case, if the prayer has come, then the prosecution has to,
Proper application.
has to file a proper application, or bring to the notice of the court. That also, because the court summato can also take up the matter.
The court sumoto can also take up, Lordship. Yeah, based on the prayer made by the IO at any format, Lordship, the court can sumoto
So
also
it
take up.
is, you see, in my opinion,
Lordship.
to bring the matter to a quietus once and for all, it would be better for this court to get the latest status report from the IO, and on the basis of such status report, then we can come to an opinion or conclusion as to whether there has been any violation of
Yes.
Lordship.
or the previous order of this court, or rather the condition set by this court. I think
My
that
lord, may I submit, my lord? Because just now the respondent, my lord, the accused persons have already stated that they have appeared before the IO and all. I believe they should first file the affidavit, and we can address
No, it
those
is there.
affidavits
It is there in the
also
report
by
itself.
the IO, my
This
lord,
report
because
itself.
IO will have to reply. If the IO is saying, if they are saying they have met the IO, and the IO is saying that he has not come and cooperated with the investigation, my lord, then it's a very difficult, tricky question, my lord. So I believe their affidavit will be very
It is.
much.
It is there in the
important,
report
my lord.
itself, my lord. It is there in the report. I will rely on this report only. It is there.
Let them
we-
file
we'll-
an affidavit, my lord. Thereafter, we can call for the status report from the IO, whether they are cooperating with the investigation or not, whether he still persists on the prayer of cancellation of bail or not.
My lord is right, correct. That latest report, that will suffice, I think. Because everything is here in the report itself that he has appeared. IO has himself said. If I will be allowed to read, then I will read, your lordship. It is there. That is statement recorded. He has appeared. He has appeared. All the formalities has been fulfilled. Everything. But now again the IO is calling. That is the difficulty, because we have intimated to him also that
we will see if you have intimated to him
yes,
that you are sick, or let's see what he
yes,
has to
yes.
say on
That it is in the report itself, my lord, that he has appeared.
See, miss, you have to understand the stage of the case.
Lordship.
It is only dealing with bail,
Lordship.
bail consideration.
Lordship.
Whether bail is granted, bail is not granted, but that would not affect the overall merits of the case. It is up to the IO to find out the truth. He will
Yes.
file the charge sheet if so, if that is his finding, and the matter will proceed. The matter will proceed. If in the course of investigation or in the course of proceedings, your interest or anybody's interest is affected, that will also be taken into account, and an appropriate order will be passed by the competent court, even by this court if so required.
Lordship, better Lordship than called for fresh report, because Lordship, once, yes Lordship, I agree that he has he might have come before the IO. He might have at present he might have come before the IO and also given his statement. But Lordship, for mere investigation, Lordship, what we know is that there are other formalities apart from recording the statement, Lordship. There are other formalities. There are formalities like making seizure. There are formalities like taking the signatures. There are other investigation required wherein, apart from recording the statement, Lordship, for which the presence is required. And that is why Lordship has already indicated in the clauses that he shall appear before the IO as and when required. But Lordship,
that is why it's up to the IO to now to file a report and say that yes, he has appeared or yes, he has not appeared.
Yes, Lordship. Let fresh report be, because this is after vacation it has come up.
Exactly,
What might have, yes, Lordship, let fresh report be called for.
May I submit, my lord? I firstly, my lord, I would like to tender apology. It is on record, the status report, because my IO should not have addressed it to the court, my lord. It seems he has addressed it to the court, my lord, which is apparently cannot be allowed, my lord. And it should have been addressed either to the PP or additional PP. And it seems he has
referred directly.
It is absolutely, my lord. I tender my unconditional apology for that, my lord, because he could not have addressed to the court, my lord.
I think that some observation also was made on that, I think.
So, my lord, I believe my lord will kindly accept our apology and give us another opportunity and to file any report, but should not be addressed to the court, my lord, through the counsel concerned. It is the dignity of our courts, my lord, which is at stake, my lord. So, I tender apology for that, my lord.
Anyway, we will this court will look into the matter if the previous status report is to be taken into account or not. But as far as this matter is concerned, as also agreed to by the petitioner, we will get the latest status report. It is incumbent upon you to advise the IO accordingly. It is
Yes,
not.
I'll definitely do so, my lord. But my lord, in this case, my lord, for the prosecution, Madam N.G. Sheila was appearing, my lord.
My lord.
So I will inform her, my lord, and I believe, my lord, will work it out whether
Yes,
she will take the step.
that's
or
up
I
to you.
take the step.
That's up to you.
My lord, in the report itself, your lordship, everything is clear that he has also submitted all the original documents. Everything he has done. But now at this stage, your lordship, again and again, this accused person has been called.
Between, like I said, between the last order and today, what has transpired?
Yes. So that also, your honor, if your lordship will call, I have no problem. But it amounts that your lordship, like, it is the investigation is going under the monitoring of the honorable court.
Oh, nothing of the sort.
Yes.
There is no.
The IO will be under pressure again.
There is no specific order for the IO to conduct himself in a particular manner.
Yes.
Yes.
It will impact the IO.
Well, how can it? The court has just sought for a
All right.
what he has done.
Yes.
It is not that this court is monitoring what he has done,
Yes, yes.
but he is to inform the court what he has done in the light of the
status.
The petition that is being filed before the court.
All right.
We will look into that.
Yes,
Lordship.
However, my lord, another aspect of the matter is that, my lord, coordinate bench also has already held that the petitioner does not have a capacity to pursue, my lord. That also has to be kept in.
That if you have that order, you can.
Yes, we will place your lordship. That one also.
Because
In the same
our
case.
duty, it is our duty to inform,
Naturally,
my lord.
if that is the case, you can always produce a.
Yes,
Yes, yes.
we'll do
And
so.
my lord, we have.
take that into account if this
My
if it
lord-
has relevance to the.
Yes.
Lordship,
My lord,
in that case, that
my
is
lord-
different case,
My
Lordship.
lord,
That
no, no,
in
that
that
same
case,
She is the
Lordship,
complainant in that case. She is the
Lordship,
complainant in
yeah,
that case.
Lordship,
In spite of that, she was not allowed.
No, just wait.
that is a different case, Lordship. The case is that in the bail stage, I interfered. It is a different case. Here, as a cancellation, the third party, Lordship, I had already placed some judgment that third party interference is also there, possible in the, even the court can take, in the bail case, it is not there that court can take suo motu and grant bail. No, Lordship. Here, in the cancellation of bail, if court comes to know about that,
Exactly, that is,
the court can take
that's what this court has observed.
Yes, yes.
Lordship.
Yes.
So the
But
case is totally different,
even
Lordship.
even for the court to take up the matter suo motu, there
Lordship.
must be some materials.
Some
Lordship.
See, and what best material if not the report of the IO?
Lordship.
Because the IO is handling the matter.
Lordship.
the stage of the case is still under
Investigation. My lord,
No
one
charge sheet has
aspect,
been filed.
one aspect of the matter I just wanted to bring to that we have even challenged the whole entire proceeding under section 482. So that is also pending. So,
You see,
it will not
when the
happen.
matter comes up,
Yes.
see, anything that would have a
Relevant.
bearing
Yes.
as far as this issue petition is concerned,
Yes.
you are at liberty to do so,
Yes, yes.
and the court will decide whether it's relevant or not. Heard Ms. Shadi, counsel for the petitioner. Also heard Mr. S. Pandit, counsel for the respondent number 2. Mr. S. Gupta, additional PP, has appeared on behalf of the state respondent. At the hearing, the consideration of the status report filed by the produced by the IO produced before this court by the IO, which report has figured in this court's order dated 17/12/2024, was taken up for consideration. However, at this point of time, the learned counsels across the board has submitted that the IO may be directed to file a fresh status report for this court to be clarified on the latest position as far as the investigation into the case is concerned. As to the issue on the maintainability of this petition vis-a-vis the locus of the petitioner hearing, the same will also be heard on the next date fix. Accordingly, on consideration of such submission, the I was directed to file the latest status, to produce the latest status report on the next date fix. When do we fix the case?
It did come after 3 weeks.
This is from which district?
From Garo Hills.
From Tura Lordship.
West Garo Hills. Let it come after 3 weeks, my lord, if possible.
So we'll fix it on 20th then.
20th. Let it come on 21 or 22, your lordship. 20th, I will be out of station.
21 is
after 20. Let it come in.
21 is a holiday.
21 is a holiday, Lordship.
This is Madam 24th.
Yes.
Monday.
Monday, Lordship.
24th.
जज को लिख दिया हम तो देखा नहीं हमको तो बब्बू लगाना था जज को लिख दिया यार so stupid इसलिए कुछ बोलने से पहले आई टेंडर्ड अपोलॉजी की दिस शुड नॉट हैव हैपेंड ना और ये प्रोड्यूस भी करता कोर्ट में यार हाउ स्टूपिड जज को लिख